Good afternoon. Welcome to Grace and Gavel, where truth meets compassion. Today we're doing episode 2, The Invisible Witness, When Winning Matters More Than Truth. Act 1, The Evidence That Never Saw Daylight. So, after the bust, there were key pieces of evidence that were collected. One of them was some paraphernalia, the other was a scale, and the other was the substance of choice. Let me introduce you to the defendant. He is a lower socioeconomic status person who is often unknown, unrecognized, maybe not from this area, and is also unprotected, who has been dealing with addiction for quite a period of time. The trial here is going to happen very, very soon. However, there are certain key pieces of evidence that have either been lost, the chain of custody has been broken, meaning that it hasn't been able to be tracked throughout the system, and it's potentially an issue where either poor management of the evidence or a scenario where someone has come in and taken the evidence. So the issue with this is whether or not this person is going to get a fair trial. Most likely, their family can probably not afford an attorney. Additionally, they have the other aspect of them being a person who has struggled with addiction. So they do have multiple substance abuse offenses, which could potentially be used against them or potentially elevated to a habitual offender, which increases the amount of time that they will be in prison. In some states, there are actual designations between those who are actual users versus those who are actual distributors. So understanding the analysis of addiction versus someone who's actually kind of being a predator on other people to get them into the addiction cycle. And then let's talk about what a Brady violation is. A Brady violation is actually when the state has evidence that is favorable to the accused. For instance, let's say, for instance, that the gentleman that I just described hypothetically is being accused of being a dealer, a person who distributes this drug because he has a scale and he has other things. But the state has awareness based on surveillance and other evidence that they have, as well as CIs, which are confidential informants, who have said, Bob is not a dealer. Like he doesn't deal. He literally is a user. He's a person who has used this substance for a period of time. He's been through a lot. He's had a hard life. He's not a distributor. And so this evidence is not making its way to the defense counsel so that they can actually use this information to potentially keep him from becoming an habitual offender, rather keeping him on the user track, which is a much more it's a much less potential of time for him. It's much less time for him to do if he were to be found on the user track versus on the offender distributor track. And this is trying to be suppressed by the state. And it's material to the guilt and the punishment. Materiality is often the most misunderstood. And it's material because it determines what track he's on. It determines if he's guilty and what punishment he deserves, given the law. It's all within the legal framework of that. And so material means relevant. What is relevant to him, right? It's relevant that he's not a distributor. It's relevant that he is a user, a person who has used the substance, which often gives you a lesser sentence. But the state's trying to suppress that, which ultimately, a Brady violation is when something that should come to the defense counsel because it's favorable to their client is suppressed and not given to them. Because that is a violation. For instance, the Brady violations often happen when you have an example of somebody else's fingerprints being there at the scene rather than your client's. There are other people who have a nexus potentially to the crime, things like that, that are favorable to your client. Then there's also accidental versus intentional suppression. Now, if let's say that the prosecution accidentally suppressed this, not really understanding like how it fit into the grand scheme of things. And I mean, that's possible. A lot of prosecutors are busy, sure. But it also comes down to management, and it also comes down to being able to stay on top of the evidence that you have, being able to disclose the discovery. The discovery is the evidence that they have against you. And so clients need to know that, defendants need to know that, defense attorneys need to know that so they can prepare a worthwhile defense for their client. Oftentimes they have tunnel vision. They may not fully see how it fits in. They have a lot of cases. Some of them are overworked. Also, too, some of the office culture. I mean, there are some very competitive prosecutors in certain areas where I'm from. There are prosecutors who refuse to give offers just because they want people to go to trial so they can have the highest amount of time from them that they can get. And then other people say, I didn't think it mattered. And that is an excuse that will fail every time, because when a defendant has a case, it's really important that they have all the evidence to be able to mount a defense. And the fact that a prosecutor would say, I don't know, you're not doing your job. Your job is not to win at all costs. Your job is to put a fair trial on without bias. Your win record doesn't matter, especially if you're keeping evidence from people who need it. And then Act 4, the long road back. Again, you then might have an issue with, then you have to go through the post-conviction relief where you try to appeal the case. And that can take a while, depending upon how booked the appeals courts are. Could take years or decades lost, potentially. And then the emotional toll of proving that you're not guilty after a conviction. I wouldn't say innocence, because you can't really prove innocence. It's either guilty or not guilty. And so going through that and the amount of money that can potentially take can take its toll on family members and such. And then also there's the prosecutorial power and moral injury. The prosecution, as a defense attorney, the prosecution has all the power. They have the power to bring the cases. They also have the burden of proving the cases. The defense attorney has no mechanism other than suppression, which is when certain things can be suppressed and potentially cause the case to crumble. They also have the ability to do depositions and search for evidence and things like that. But ultimately, the prosecution decides what cases to take and what cases to not take. And oftentimes, an unwritten kind of thing is the fact that certain defendants get a lot more cases based on previous contact with the prosecution. I know a lot of times they don't want to admit that, but that can be true. And ultimately, accountability can be rare, because they feel like, hey, we have this moral thing going on. We have the moral high ground. I will say, though, that I've worked with a really good prosecutor in my area, and I have a lot of respect for him. So, but also there's like an ethical tension, justice versus conviction rates. And ultimately, I don't think that any of that has any place in that. It should be based on the law, and there should be no count, so to speak. Oh, I won this case, I lost this case. Doesn't matter, right? Justice is the name of the game. So in closing, the most dangerous evidence isn't false evidence. It's the truth that no one was allowed to hear. And there have been many cases like that. If you're a true crime junkie, you know there are a lot of cases like that. So thank you for tuning in to Grace and Gavel, where truth meets compassion. My name is Buffy. I'm an almost 18-year criminal defense attorney, and I thank you for tuning in. Hope you have a great day. Bye-bye.